Chairman, thank you, Mr. Comey, for being here today, and thanks for your service to our country. I want to talk to you about something raised by one of my colleagues a little while ago about electronic communications transaction records. Would it be fair to say that electronic communications transaction records include such things as browsing history, one's history of websites that one might have visited on the Internet?
Yes.
Would it be fair to say also that what one views, what pages one has visited, might in some ways be indicative of what one is reading?
Potentially, you're right. Even if you don't see where they went on the page, that they went to ESPN or Fishing Magazine, gives you some indication of their interest. Yes.
Individually and collectively, you can find out a fair amount about a person, especially if you're able to review what it is that they've been reading for a certain period of time.
Right. The only reason I'm hesitating is, as I understand it, we can't look at, all we can get is the websites visited, not where they went on the page or what they clicked on. But it does give some indication of your interest, just like who you call gives you some indication of your interests.
But where they went on the website will also be indicative of what they did on the website, would it not? I mean, if you can get that granular information about what subpart, not just that they went to ESPN, but they went to ESPN and read this or that article.
Right. My understanding is that we can't, with an NSL, as we understand the statute, get that sub-content. We can get the web page visited. We can't get where they navigated within the website. That's, I may be wrong about that, but I think that's how we are.
Within the existing confines of the law.
Correct.
And so for those who are proposing that we change existing law so as to allow you to use a national security letter to go further, as was suggested by one of my colleagues earlier today, that then would allow you to get this more granular information.
No, I'm sorry. I may have screwed this up. As we understand the way ECTR was intended to be used, that our NSL authority under ECTR, as we thought it was and as we hope it will be changed, is limited to that top-level website visit address.
Correct.
So even if it's changed the way we hope it will be, we don't get any deeper into what you looked at on a page. It's as if we're able to see what sporting goods store you called. We can't tell from the call record what you asked about. We can see what sporting page you visited, what website, but we can't see where you went within that.
Yeah. Based on the legislation that I've reviewed, it's not my recollection that that is the case.
Okay.
Now, what I've been told is that it would not necessarily be the policy of the government to use it to go to that level of granularity, but that the language itself would allow it. Is that inconsistent with your understanding?
It is, and my understanding is we're not looking for that authority.
You don't want that authority?
That's my understanding. What we'd like is the functional equivalent of the dialing information, where the address you emailed to or the web page you went to, not where you went within it.
Even if you look at it at the broad level of abstraction, so if you're suggesting it would be used only at the domain name level, somebody went to ESPN.com, if you follow someone's browsing history over a long period of time, you could still find out a fair amount about that person, could you not?
Yes, sure. And again, I keep saying this, but I mean it, as you can from their telephone dialing history.
Yes. Let's talk about Section 702 for a minute. Section 702 of the Foreign Intelligence Surveillance Amendments Act authorizes the surveillance, the use of U.S. signals surveillance equipment to obtain foreign intelligence information. The definition includes information that is directly related to national security, but it also includes, quote, information that is relevant to the foreign affairs of the United States, close quote, regardless of whether that foreign affairs related information is relevant to a national security threat. To your knowledge, has the Attorney General or has the DNI ever used Section 702 to target individuals abroad in a situation unrelated to a national security threat?
Not that I'm aware of. I think, I could be wrong, but I don't think so. I think it's confined to counterterrorism, to espionage, to counterproliferation, and well, those are the buckets.
Okay,
I was going to say cyber, but cyber fits within.
That's where it has typically used those things. Does it, so to your knowledge, it doesn't currently use Section 702 to target people abroad in instances unrelated to national security threats?
I don't think so. Like a diplomat to find out how someone feels about a particular foreign policy issue or something. I don't think so.
Right. So if Section 702 were narrowed to exclude such information, to exclude information that is relevant to foreign affairs but not relevant to a national security threat, would that mean that the government would be able to obtain the information it needs in order to protect national security?
Would seem so logically. I mean, to me, the value of 702 is exactly that, where the rubber hits the road in the national security context, especially counterterrorism, counterproliferation.
Okay. Now, when Section 702 is used, typically what we're talking about here is not metadata. It's not this call was made from this number to this number. This is content. And so if we were talking about two U.S. persons, two American citizens, if I were calling you, typically that's not something that Section 702 would be used to collect. But if it's me calling someone else, and if that person is not a U.S. person, if that person ends up being an agent of a foreign government, and if somebody has determined that communications involving that person might be connected to a national security investigation, there's a chance that that communication could be intercepted. Not just the fact the call was made, but also the content of that call.
Correct. That's what we call incidental collection.
And that incidental collection is then aggregated. You have databases that store all of these things. And so there are lots of U.S. persons who have had communications, conversations that have themselves been recorded that are out there in a database. Can you search that database for communications involving specific U.S. persons without getting a warrant?
Yes.
And the fact that these communications were intercepted without necessarily any showing of wrongdoing on the part of the U.S. person, without necessarily showing that that U.S. person had anything to do with the with the national security investigation at issue. Does that cause you concern that that could involve almost a backdoor way of going after communications by U.S. persons in which they have a reasonable expectation of privacy?
It doesn't cause me concern, but maybe because of the way, what I can see from where I am. I understand the question, though. But it's true, whether it's 702 or other court-authorized domestic surveillance in the United States, if we are covering a particular embassy of a foreign power and Americans call in and speak to them, we record that because we're authorized to collect the communications in and out of that embassy. And we store all of those in a database, or we have lawfully collected those, even though the American who called wasn't a target. The same happens with 702. If you contact or call a terrorist or someone we're targeting overseas, you're an American, you have a conversation, even though you're not the target, that's going to be collected and stored in a database. What matters is how we treat that data and that we're careful with it and we don't use it willy-nilly and we protect it in important ways. That's true whether we collect it in 702 or collect it domestically. I don't know how we would operate otherwise, and that's, yeah, I don't know how we would operate otherwise. I think what the American people want us to do is make sure we hold it so we can connect dots if it turns out there's something bad in there, but treat it like the U.S. person information that it is, protect it, and make sure that it's handled in a responsible way.
Senator Lee.
Thank you.
Thank you. Thank you, Mr. Chairman.